Can anybody hear me?
Yes, sir, we can hear you.
Okay. Thank you very much. Thank you very much. So thank you everyone for joining us on this panel session, discussing the challenges and requirements for an efficient technology practice. Today on the session we have Mr. Olumide Oshundelore, who is a partner at Banwa Nigudalo, and we have Mr. Mohammed Saleh Yusuf, who is the head of telecommunications law and regulations at the NCC, National Communications Commission. Today we'll be discussing how technology has become central to how business is conducted, how government regulates, and how individuals interact, and the response of law firms and law departments to these interventions. So to set the foundation, I would like to start with a broad question to both panelists. Mr. Shudolore and Mr. Saleh Yusuf, from your experience, what are the requirements in terms of skills, internal structures, and professional mindsets that is necessary to build and sustain an efficient technology law practice?
Who do you want to speak first?
I think we'll take you first, sir.
All right. So I'll say number one, you need knowledge of the law, law of contracts, IP, corporate transactions, coupled with should I use the word technical fluency? In short, you need to know what you are doing. That is number one. There must be knowledge. And then secondly is that you then need to have an internal system, an internal process that enables you to provide legal service as quickly as possible. That process will be something I would call multidisciplinary, such that when the client stands before you, you are able to identify all the issues that the client has laid before you, and you have the competence to address all those different issues. And then finally is the mindset. You need to have a problem-solving mindset. You need to have a mindset that lives for identifying problem and solving the problem, and that includes preparing to solve the problem. So one will be the skill set, which is knowledge of the law. Two will be the internal structure to enable you solve your client's problem. And three will then be the mindset, the attitude that ensures that the client's problem is solved. Thank you.
Thank you so much, sir. Very, very instructive. Thank you, sir. Mr. Mohammed Saleh.
Okay, just to correct, it's Sule, not Saleh, but fine. Thank you for having me here. I'm happy to be here. And I would like to also write on what Mr. Sudolare, I've been mispronouncing his name, I'm sure he has forgiven me many times. Mr. Olumide has made quite clear. But for me, for me to be clear about what I think about this, I want to separate it into two. One, for a law firm to meet up the challenges of now, it has to be technology driven. That's one. So I want to separate technology into usage and then understanding. So if you're a law firm in current times, you must be able to rely on technology to also give services to your clients and be able to also be faster, be more current, and be able to provide technology-driven advisory and services to your clients. So that's one part. Then the second part is, which I think the most important one is, you must have an understanding of technology. So if you are providing an advisory on artificial intelligence, on maybe analytics, data analytics, and all those issues, that you must have an understanding of how it works. So if an AI-driven tool causes harm, if you're going to advise your client, you need to understand how it works, how the algorithm is. You need to even know what it can do, so that whatever advisory you are situating will be based on your own personal understanding of that. So for a law firm to meet this challenge, it has to operate on two levels. At the operational level, relying on technology, and at the strategy level, dealing with their clientele. Because, for example, traditional issues like jurisdiction will have been altered by technology. Traditional issues like damages and liabilities will have been altered by technology. So for you to give me advice, you must know what it is, and you must know that technology itself as a basic knowledge. I'm not saying lawyers should be engineers or lawyers should have that kind of IT knowledge, but lawyers should understand the basics. So I'll come down to my industry, my sector now. If you're providing advisory to one of the licensees of the Nigerian Communications Commission, you must understand spectrum. For example, how spectrum works, how the technical specification and standards are, how type approval works. So that kind of knowledge will not just support your advisory, will also support your law firm's engagement of their clientele generally. So that's my feedback to this, but I'm riding on what Ms. Olumide said, basically, that you need to have skills, knowledge, understanding, and then factor in this as part of your process. Thank you.
Thank you very much. I'm hearing from both panelists is that there is an important reliance on skill set and knowledge. Flowing from that, Mr. Trusted and proactive rather than reacting to new technologies and developments and innovations that our clients would demand.
Sorry, you may have to ask the question again. I think we lost you for a few minutes at the beginning of the question.
Oh, my apologies, sir. So I was saying that from the perspective of a full-service commercial law firm, how can a technology practice or a law firm remain strategic and proactive rather than reactive to the new technologies and innovation that our clients may demand?
Thank you, Tolu. So a reactive approach means that you wait for things to happen and then you start taking positions, while a proactive approach will be that you are anticipatory in your approach to the practice. And everybody will agree that the best position to be will be to be in that proactive environment. And largely that revolves around, like you remember I said that the skill required is the structure, and I said skill, structure, and mindset. And so it starts from a mindset that understands that you need to be at the forefront. You need to be seen as the law firm or the provider or the service provider or the advisor that you go to when you have a problem in this field. And so that means that number one, you need to have in place a structure that scans the horizon, a structure that's constantly reviewing developments, both operational developments and regulatory developments, both within your jurisdiction and outside your jurisdiction, so that you know what is going on. You are able to, for instance, match what is going on in another jurisdiction with what is going on in your jurisdiction. My team members will see me from time to time. I will get a judgment in Europe, and I will ask them that, look, if this case were to have been instituted in Nigeria, what would be the decision? What would be the decision? What would be the decision in Nigeria? Things like that, so that you are anticipatory, and then you begin to then take position. From there, you then take another position. Another thing you'd like to do is also what you call thought leadership, where you take position on emerging issues, and you write articles, you do webinars, and so that you inform the public of what the issues are. You try to guide in formulating responses, in formulating policies, and you find that from time to time, as you do that, you begin to build expectation both from clients and from the industry about you and about your practice. The other thing is also interacting with the operators in the industry. You need to be a member of any of the trade associations or the professional associations in that field, which gives you opportunity to interact with operators, to hear them, feel their pain, and to be able to understand where things are going. A lot of times it is in places like that that you hear what clients are feeling, where they want to go. At times where they engage with regulator too, you understand what regulator is trying to do. You're able to merge everything together. And as an informed advisor, you're able to provide opinions, provide position, and to also give guidance either to the regulator or to the operators based on your knowledge. So being a proactive service provider, number one, you need to understand your field. You need to have in place structures to ensure that you are constantly abreast of what is going on, either from the regulator or from other jurisdiction or among the operators, and that you also put yourself in a position where you are able to prefer, even if you cannot provide definitive position or response, at least you're able to provide reasonable and rational positions based on evaluation of relevant laws and principles applicable. Thank you.
Thank you so much, sir. There's a lot to take from your answer, but I'll pick two. Develop a structure that scans the horizon and interact with the operators. Do not wait for the judgments to get to Nigeria. Read foreign judgments and assess their understanding of the situation. Thank you so much, sir. Dr. Saleh Yusuf. I'm sorry I've been using the prefix Mr. It's Doctor. I'm so sorry, sir. Dr. Saleh Yusuf, from the regulatory standpoint, what level of literacy, in your opinion, do you think a technology lawyer, quote unquote, should possess to operate efficiently? Especially considering the ever-developing nature of technology, sir.
Thank you, moderator, and I'll be insisting on you slaughtering a cow for calling me a mister. But
my apologies, sir.
Permit me to, I think Mr. Olumide made points, but I intend to be radical in my response. With being from the regulatory part, I think if you want to be a lawyer of today, the lawyer of this moment we are in, you cannot be having that traditional mindset we used to have. So the point I'm making here is you cannot expect predictability in rule-making processes. So those days we know that a regulator will always go this way. But because of the way things are moving now, regulatory agencies and regulators have been challenged by technological changes and sometimes by even the way technology has evolved into several services. So, and that has also created issues of cross-disciplinary, cross-jurisdictional problems. So if your own maybe expertise has been telecommunication, you have been there, but unfortunately over time, competition, consumer matters, land-related matters, issues that ordinarily would not be telecom related become something that you have to face. And then you have a client that will have expectations that you're going to resolve these issues as a one linear process. So a lawyer in the modern times, a lawyer of today, cannot be a Nigerian lawyer. He has to be a lawyer without jurisdiction in his mindset. He has, like the example Ms. Olmide gave now, a decision somewhere in Strasbourg in France will have impact on something happening in Abuja or Lagos. Then you also have differences in laws, differences in procedures. Of recent, I was discussing with someone, even those things we used to have of civil and common law demarcation between jurisdictions has gone. So because when I'm talking about online activities, online transactions, or technology-driven activities that have no locational identity, how do I, as a lawyer, come down to those traditional questions about where my client is, who my client is, where is it, what happened, where is the point of activity, which court shall I go to? So I believe now is a necessity. It's not even an additive now. It's a necessity that every lawyer should have a clear understanding of technology. And this technology I'm talking about goes to as something as easy as WhatsApp, Instagram. You must be able to know how it works. So if your client walks into your office and says someone has malign my character on TikTok, if you don't know what TikTok is, you have already lost a client. And if you know what TikTok is, and all you do there is go and watch content creators that make you laugh, you most likely will not be able to advise. But when you understand the algorithm of how TikTok works, who owns the content, what are the liabilities, what is even the content liability that you have online. So my point here is, that's why I said I'm going to be radical. You cannot be the lawyer of yesterday today, because tomorrow is already here. So you have to be in such a way that your understanding of the law is mirrored across technological platforms, over-the-top services, cross-jurisdictional problems, telecom, technology, competition, consumer protection, data protection, data sovereignty, data warehousing, data analytics. All of these things have no national boundaries. All of these things I have listed are not in any country. Then lastly, let's talk about even issues of what happens on the cloud. I have struggled to know if you can even pinpoint a cloud service to a country. Is it where the data center is? Is it where the service was given? Is it where the beneficiary of the service is? So in concluding, my own take on this is that while regulators are struggling to keep up with technology, I must admit that while we are struggling to keep up with technology, while we are struggling to keep up with the evolution of services, while we are struggling to also work around these challenges, the lawyers and the legal practitioners working with us, particularly with some of our licensees, will have to move with us. So we all need to move together so that participatory rule-making process will benefit from this diversity of knowledge and most likely also differences in understanding. So that's my take on this as a regulator. Thank you.
Thank you so much, Dr. Sule Yusuf. Very, very informative response. One of the key things you said was that lawyers should not expect predictability, especially from regulators, given the nuances of the development of technology. That's very, very instructive to all of us. Over to issues surrounding operational and practice management challenges, especially within law firms. Efficiency is not just about the law, it's about how practices are run, how the response times and all of those things to clients. So this question is to Mr. Ofundoluwa. What internal law firm challenges most affects efficiency in technology practice? So things like billing models, client expectations, and firm cultures generally, in your experience and your very wealthy experience, what challenges would you see affect the push for efficiency in technology practice?
I suppose primarily I would probably say firm culture, and that is where you have a firm culture that that works on a, shall I say, the traditional law firm paradigm, and fail to see that these new areas, these funny technologies may be the future, and that it is necessary to develop a structure that encourages expertise in those fields. And that will also then, should I say, involve billing, among other things, to show that, because really for billing should identify value. And so when you are talking about efficiency, you want to structure your billing to recognize and drive value, drive efficiency. What are you billing for? What are you rewarding? Essentially, because what you reward determines what you value. And then automatically what you then find is that the firm will build structures around that. So that would then mean that you need a structure that encourages investment in emerging areas of practice, particularly technology practice, irrespective of whether at the moment the money coming in is small or large. You need to put in place a system that reward good and encourages good service. I tell my associates that one thing you need to understand, that look, you may see yourself as a lawyer, but you need to see yourself as a commercial lawyer. You use your legal services to provide solutions to the client. And so that means that you need to develop a structure, that a mindset for the firm that sees that, look, you're a solutions provider. And so it is a solutions provider that is rewarded, and it's a solutions provider that is encouraged. And that way, you then start structuring and putting in place everything that ensures that you work in an efficient manner. That is what I will talk to. That every other thing that you do is a function of your approach to practice. And so that is the key thing. What's your approach to practice? If you have an approach to practice that, number one, recognizes and value excellence, and then every other thing will be structured around that, including billing, including remuneration, including resourcing, among other things. Thank you.
Thank you so much, sir. Thank you so much, sir. So this next question is nuanced, and it's directed at both panelists. So how can, practically speaking, how can lawyers deliver commercially practical advice and value without crossing or crisscrossing non-legal and legal operational roles? So I would want Dr. Sule Yusuf to go first.
Thank you very much. I when I had the question, my mind also goes back to how can they not do that also? Because I've noticed over time that no lawyer can be in one field, or no lawyer can provide advisory that is that restrictive. I have discussed with a lot of lawyers. I've engaged a lot of lawyers within our ecosystem, mostly lawyers that deal with telecommunication issues. And quite a good number of them are quite smart and good. But I have noticed one thing about them. They are also so cross-functional and so cross-jurisdictional that at a point in time, you even worry about whether they are looking at too many things at once. But because of the nature of what we do and because of the cross-cutting nature of what they are looking at, sometimes it's inevitable that in both your services and advisory, that you may have to look at multiple areas and multiple activities that may not naturally be within the purview of what you were asked to advise on. I will be very practical by giving an example. So if a network operator, maybe with their license from the Nigerian Communication Commission, engages a law firm and asks about advisory on a submarine cable that is landing in Lagos, at that point in time, it might look straightforward that someone is landing submarine cable in Lagos. But if I tell you the nature of activities and the kind of engagement that law firm will be required to carry out, it will amaze you. For example, they will have an international component of it because that submarine cable it came from a destination. So they have to look at that. And then they will have to look at local laws, which even includes local government laws, state laws, and they have to now look at regulatory and licensing expectations from the Nigerian Communication Commission. Then they will have to look at competition-related challenges. So by the time you look at it, it's a bucket full of so many things that sometimes you wonder how that lawyer can keep up with those expectations. So my response to you, sir, is that any lawyer that wants to play around an area that has such fluidity and such cross-functional implications has to be agile. So agility is almost like a surviving tool, and he has to be agile enough to move around, and he has to be amoebic enough to also adjust so that whatever issue comes up, you'll be able to look at it from a maybe a multifocal viewpoint, and also rely on the traditional legal concepts that he is already well versed with. So is that a company of activity or so many congregation of activities that I expect that lawyer to put down so that whatever comes out of it, the output would give his clients a wholesome advisory or review that will guide them against maybe breaches that will lead to some enforcement actions. So that client will actually benefit from this cooking that I'm talking about, so that whatever comes out of it will not leave any gray areas and will not also expose them to any liabilities. So for me, that's my feedback. So that's why I said, when I heard your question, my mind now comes to what else can they not look at? It's almost like saying, look at everything. Because by the time you finish the advisory, it might have impact on everything. So that's my feedback on this. Thank you very much.
Thank you very much, Mr. Shunduru, sir.
All right. So what I do in situation like that is to say that, look, I help you. So my approach to practice is to say, like I said, I'm a solutions provider. I enable you to take commercial decisions that result in making money. So I do my review, I do my research along the lines that Dr. Sule Yaya said. I'll do that. Then when I'm presenting my advice to you, I'm presenting my advice to you in options. Here are the options available to you. Here are the implications of those options, so that that way you can see your trade-off. If I take this, these are the advantages and these are the disadvantages. If you do that, this is the advantages, those are the disadvantages. So which one do you think you will do? And that enables the client, depending on their commercial objective, depending on their risk profile, among other things, to then take a decision, knowing to take an informed decision, having been provided by their legal advisors the various data that they need to consider in taking a decision. So essentially, that is what I will suggest that a technology lawyer should do. You should, and to do all this, remember all that we have been saying. Number one is that you need to be versatile enough to know the issues in the system. Number two is also that you need to be conversant about the industry. You need to you need to be familiar with the issues in the system. You need to have industry knowledge, industry and regulatory relationship to also understand all these issues, so that when you advise it, as a matter of fact, in certain instances, you may even have to advise to say that, look, we in previous engagement with the regulator on this issue has shown that this is the way the regulator thinks on this issue. And therefore, you need to take that into consideration in taking a particular decision, among other things. So it's really wide. It comes from experience, but it also comes from that desire to be the advisor of choice and to understand that your decisions result in financial implication, and therefore you want to be sure that your client is well positioned to take the best decision in the circumstances. Thank you.
Thank you so much, sir. Thank you, sir. That was very instructive. Dr. Sule Yusuf, there is oftentimes a divide between public sector lawyers and private sector lawyers, and there's like this them versus us type thing that goes on, especially with the younger generation. But from the conversations we've had today, what the future has for us is that we have to work together to achieve most of the goals when it comes to dealing with technology. Now, with that backdrop, sir, how would you advise a young lawyer or any lawyer at all that wants to get into public service as a technology regulator? Dr. Saleh Yusuf.
Okay, thank you very much. I wasn't sure you were done, so thank you very much. Thank you. I don't know about the divide, but I agree with you that maybe because of the conjectures, yes, it's possible that maybe we may be thinking differently. But I think over time, because of what I do, I think we have been having that kind of relationship where we have a symbiotic relationship with the lawyers in practice. So, for example, because of the way the Nigerian Communication Commission works, we have an inbuilt process of participatory rulemaking. So whatever we need to do, we are going to develop a regulation, a guideline, or whatever directive we need to issue, we engage. And we engage these lawyers informally and formally. So I have quite a good and intense relationship with a lot of lawyers in practice. And I think I have benefited immensely from the experiences they have garnered over time. And I also suspect they have also benefited from our relationship based on some of the discussions we have had. So for a lawyer that will join the public service, I think it's important to remember that what is important is the output you provide and what happens when you do that. So when you are making rules or you're making regulations, I think at the back of your head, you should always remember that it's not just going to be on the shelf in the office, it's going to be deployed into the system. And the people that will implement, apply, advise, interpret, and in some instances, advise their clients on this are lawyers and legal practitioners out there. So I think it's quite important and quite necessary that they are also part of the process, either at the incubatory level, at the conception level, or even at the point of implementation, so that whatever comes out of it, you'll be able to have a diverse group of people that have a buy-in into what you have done, and they understand clearly the thinking behind it and the intentions behind it. Because most times, if a law is theoretical and just out there without people even understanding the legal principles and basis for the issuance, is always difficult to implement. So my advice to even both the public and private lawyers, especially a young one, of recent I've realized I'm old. So for those that are very young, that are joining the legal services of government or working from the private, I think the advice will be universal. You should remain focused. Focus on what is happening, understand what has happened, and get the skills. Because I don't think the skills you had yesterday will help you today. So you have to continue upskilling, you have to continue learning, you have to continue reading. And then the last advice I would give is formalization of relationship is good, but it's always beneficial to have close informal relationship with people across different spectrum. So it's good to build a relationship either with lawyers in practice or lawyers in government services where you can informally even converse about certain activities, and then you can get easy, free guidance when you need it without having to go through the formal steps. That also would be a caveat that that discussion should be based on issues that can be discussed publicly. I just want to put that caveat. But other than that, my last part of this question you have asked is a young lawyer should remain focused, should learn, always should learn, every day should develop himself, and should always have that human angle of his interactions. He should interact with people and he should have to build relationships across different areas. So that's my advice.
Thank you so much, sir. Thank you so much. Mr. Ashudolure, this question is for you. Looking ahead and how the development of technology is going, how should particular practitioners position themselves for the next wave of artificial intelligence, quantum computing, Web3, and beyond, robotics, things like that, considering the stage at which Nigeria is catching up to these things? I know we've spoken a little bit on how they should position themselves, get the knowledge and things like that, but specific to these areas I mentioned, AI, quantum computing, Web3, and robotics, how should a lawyer in the law firm in Nigeria position themselves appropriately?
I'd say get knowledge. It's as simple as that. Just get knowledge. What are they talking about? What can it do? What are the likely implications? What are the ethical implications? Just get knowledge, and not only get knowledge, but stay in the flow. For how many years now, people have been talking about all these issues. I remember at the time, Internet of Things was a strange thing, was a new thing. Now, I don't even hear anybody talking about it anymore. You just need to stay in the flow. And what that means is that you need to create relationship with the practitioners, relationship with the operators, relationship with the regulator, so that when issues are being discussed, you are in the room, you hear, you go back, you do your own research, you do your own knowledge. For law firms, they need to put together a structured, well-funded training program, not ad hoc seminars. That could also be part of it, but at least there should be a structure that says that, look, at the end of the year, my lawyers should be able to do X, Y, Z. These are the kind of trainings that I will expose them to. These are the kind of accountability structure that we'll put in place to ensure that they learn and they are able to implement. And then these are things like that, so that you have a technology savvy law firm that is positioned to take advantage of development and to also guide and lead in those areas. So where are your associates? Have you spoken with them to know what they are looking at? Where is the area of interest? What structure have you put in place to encourage them in that area? Not only that, but what structure are also put in place to ensure that as they acquire that knowledge, they stay relevant in the firm, they stay valuable in the firm, so that they contribute and support the firm in its outlook and business development efforts. So that's essentially it. It's about keep knowing, and ensuring that that structure retains the knowledge and turns that knowledge into institutional knowledge that's recognized and rewarded through reputation and recognition in the industry. Thank you.
Thank you so much, sir. I'm learning so much. In fact, you've answered my next question. But before we go to the next question, I would open up questions for our participants that may have questions for our panelists today. You can put your questions in the chat just below for your question. So we'll take the first 5 questions that we get there, so that we'll not flood the session. So for anybody that has questions, you can just put your questions in the chat below and send it. We'll take the first 5 that comes in. Thank you very much. As a rounding up question to both panelists, we've spoken about technology, we've spoken about understanding the sector, the area, the business needs of our clients, and also understanding that there might be some catching up to do with the regulators. We've heard about the gaps there are between the traditional law firms and what we're looking at in the nearest future, or even looking at now. So this question goes to both panelists, and this will be our final question. Then we'll take the questions from our participants, where, if any. This question goes to both panelists. Now, there are gaps currently that quote, and I'm being very careful with the question, that quote and unquote discourages lawyers everywhere. And the gap is we see the gap most prominently in the judiciary, right? There seems to be a gap between the realities on ground and the realities in business, the realities of the judiciary and the realities in business. What advice do you have for lawyers, especially young lawyers, in approaching those gaps? So I would give an example. Earlier in the month, a court in Northern Ireland gave a fine against TikTok, 530 million euros against TikTok. And it was for data processing outside of Northern Ireland. So they were processing data that belonged to Irish people in China, which was against the GDPR, right? And the depth of the judgment was to the effect that, yes, you were processing a part of it in Ireland, but the remainder of it you were processing in China. Now, I read the judgment and I was like, how do we advance in our adjudication process in Nigeria to get to the point where we're advancing arguments like this? So that's my question for the 2 panelists. We will get to the lawyers here today to advance such arguments. I'll take Mr. Oshudolore to start. Thank you, sir.
That's a difficult one. Okay, so I would say that lawyers need to develop themselves, judges need to develop themselves. Everybody needs to, it's the lawyer that becomes the judge. And so for me, the same attitude that made you a good lawyer is the same attitude that will make you a good judge. And you just have to develop knowledge, all that we have been saying since, knowledge of the subject matter, relationship within the area of the subject matter to help you get the knowledge that you think you need, which will, like I said, entails, number one, knowledge in relationship with your peers, relationship with operators, relationship with the regulator. And so that you are constantly abreast, you understand what the issues are, and you are able to provide necessary advice, or you're able to take an informed position supported by sound judgment and interpretation of the law. and that is what we do, whether we sit at the private practice, we sit in public practice, regulators, or we sit at the bench. That's all we do. And we need to take advantage of structures. I believe that NCC, quite commendably, has been doing that, because I think on 2 occasions I've facilitated, I've presented paper at their annual judges conference or judges training that they do with Nigeria National Judicial Institute, where they actually bring judges together to then speak with them on technology related issues. And so possibly we need to have more and more of that. We need to develop a category, or should I say a class of judges who have expertise in area like that, and so that we then know that necessary issues will be directed at them. And it's important because, like we all know, legal development is not just regulatory. It's both regulatory as well as case law. And so both needs to grow together to ensure that we have a robust framework that will encourage development in the field, both commercial and jurisprudence. Thank you.
Thank you so much, sir. Thank you, sir. Dr. Yusuf Sule.
Don't worry, you will be buying like 2 cows at the end of the event. So my feedback is, I think when I heard what Mr. Olumide stated, particularly with the workshop he referred to, I just want to give an example. 2 years ago, in the same workshop he was referring to for judges of Federal, State High Court, Court of Appeal, and Supreme Court. We played a video of a Barack Obama speech for 10, I think it's about 5 minutes, a whole speech by Barack Obama. When they finished hearing the speech, at the end of the speech, we now told them that it's AI generated, that Obama never said those things. So I think a lot of them were shocked, but I give you this story just for you to understand that the nature of technology and the growth of technology has gone to that kind of level where even as lawyers, as practitioners, I don't think we have seen the boundaries of what technology can do or can achieve. I don't think we have. But now I'll go to the second part of my feedback on this. I think lawyers are not triggering the judiciary to look at these things. In the sense that the court only determines or adjudicates over matters brought before it. And when I look at the current case law, or maybe I look at law reports, it's mostly cases dealing with chieftaincy, divorce, and matters that are mostly not this type of cases. So I think for the courts to be able to even understand some of these things, they need our lawyers to also instigate or trigger cases that will bring out some of these challenges we are talking about. I'm sure the case you are talking about in Northern Ireland may have been triggered by lawyers who saw that and who also, on behalf of their clients, triggered the court to get to that decision. So our lawyers here, with due regard and respect to the hard work they have been pushing in, I think they also need to move towards this part of the realm, because gradually those traditional processes, those traditional cases, those traditional liabilities will gradually move up front into the digital world. And we may need to have to go there. And going there means we need the court to start looking at them based on our filings, because a judge on so moto cannot instigate or trigger a case of that manner or of that type. So we need our lawyers to be able to understand, trigger, and push out these cases in such a way where we'll have opportunities for decisions to be taken and build up our precedences, and then the case law that Mr. Olumide referred to will also become robust enough to provide both guidance to judges and guidance to lawyers, because case law seems to give us a better opportunity of transferring both practical knowledge and adjudicatory knowledge on some of these matters we are conversing about. So that's my recommendation on this. I think the lawyers should trigger, the lawyers should be radical about their filings, and the lawyers should be radical about the processes they are doing to ensure that whatever they are doing brings out this issue we are discussing. That's my advice on this.
Thank you so much, sir. Thank you, sir. This is very, very informational. We have 2 questions for now. The first question by Chiwendu Aziki. It says, dear panelists, are there technological tools that you believe are for law firms operating or looking to expand into the digital sector? So are there tools that you believe are must-haves for law firms operating or looking to expand into the digital sector? Dr. Sule Yusuf.
Thank you. Let's start with, there are so many free tools online. So you have a lot of AI enabling tools online. When you search them, a lot of them, in fact, what you need to do is go to Google, ring-fence your inquiry into, I need a tool that will help me summarize a case, for example. Or I need a tool that will be able to do A, B, C, D. It will give you. There are a lot of free tools, but I will also advise that when you go a bit advanced, you may also need to get the ones that are being paid for, because those ones are more secured and they have more integrity in their output. So those tools are there. But based on that, his question, I also recommend that there are a lot of free online trainings on this, particularly at the ITU Academy. So if you go onto the web, you can find the International Telecommunication Union. It has an academy that does a lot of free courses. And then the Federal Communication Commission of the United States has a training academy that also does a lot of free courses. Then in Europe, BEREC and some of those European bodies, they do a lot of free trainings, especially on issues related to using tools or issues related with understanding global practices and trends. So the internet now is available. I think it's how you use it. Whatever you need is there, it's out there. And so a lot of them, you don't need to pay for them. But I think over time, maybe in a year or 2, you get too advanced for these free tools. And I don't need to tell you that at that point, you will by yourself, you start paying for more advanced tools. But at the beginning, I will recommend and I will advise, get those free tools, artificially intelligent tools, data analytical tools that will do a lot of things that as a human, it may take you 2-3 days, in 10 seconds, you get it done. So that's my advice and recommendation on this.
Thank you so much, sir. Mr. Shundelure.
Tools. I'll probably not talk about tools. I'll probably talk about the user of the tool. Tool is as efficient or as good as the user of the tool. And I'll rather caution our lawyers, first of all, build yourself, put yourself in a position that whatever the tool you want to use, you can make the best use of that tool. For instance, and that comes from my own background where the firm where I did my pupillage in 2000. The firm could afford to put laptop or desktop for every lawyer, but the partner in charge insisted that no, that we will have a pool where secretaries will sit and will write out or type out your thoughts. He would say that, look, your job as a lawyer is to think, put your thoughts down, and then someone can type. Typing is not your job. And so it's the same thing for every lawyer. Yes, you have laptop now. Yes, some of you are so techno-friendly that as you are thinking, you can type. But that's the issue. You think first. And so the quality of the lawyer is important, really. I will advise that, first of all, get knowledge, be familiar with the issues, and then the tools will then be able to. So for instance, the quality, so if you are using an AI system, the quality of your response is dependent on the prompt that you give the system. And then so you begin to see what I say. So If you write a good prompt, you get good response. If you don't put in a good prompt, you don't get good information. And so you need to work on that. What tools? I won't name anyone. I will just say that, look, one, you need to get a document review, if possible, all of them AI enabled, document review tool that enables you to review documents quickly, identify issues, and in identifying the issues, benchmarks the issue with best practices, international best practices, applicable laws, and is also able to provide use cases, among other things. Same thing too for your research. You need a research system, knowledge management system, where you can get information about an issue, latest development, if possible, benchmarked against developments in other jurisdictions. So that way you have the benefit of broad knowledge base upon which you can then provide advice. But remember, you are the one providing the advice, not the tool. You're just using the tool to make your practice more efficient, and you won't even recognize you won't recognize the turns, the twists, the industry nuances if you don't know. What you don't know, you can't know. Thank you.
Thank you so much, sir. That's very instructive. What you don't know, you don't know. The second question from Theophilus Akimbo. My question is, what is your take on corporate law practice in which the structure is managed by professional administrators while in-house lawyers practice their skills in different areas of law? I think Mr. Anshudododa will be in the best place to answer this question, sir.
What do I think? I think that's the future of legal practice, really. I think that we need to get to that point where lawyers can be unburdened from all distractive issues and all those. So the same way, it's the same principle you find in the companies. So company will say we will outsource all non-core services so that we can focus on what we want to do. Every other thing that is not core, we outsource it so that those people who are experts in providing those services will provide those services to us so that we can focus on doing what we want to do. The same thing too. I think we need to start thinking about how to build a law firm where lawyers will be focused on lawyering, and all the other things that make a law firm work will be handled by administrative experts. And so that way, enabled by technology, so that way lawyers focus, they sit down, they do the work, they bill. That way, if you are doing billable hours become more efficient. If you are doing lump sum also becomes efficient in that your lump sum does not then cover both billable hours and unbillable hours and everything. So I think, yeah, that's a future, and aided by technology. Note that, aided by technology. For instance, I look forward to a day where I'll sit down in my law firm and ask the AI-enabled practice management platform where I have installed to analyze certain data and provide for me possibly the top clients in this field, how certain laws that will impact on them, so that way I can put together a marketing plan for the next year on these issues, things like that. So that way, at the end of the day, when I'm going to sit with that client to make a pitch, I have all the information. I'm just telling them, do you know that last year you did this? Do you know that last year this impacted you? This is how we can help you mitigate those issues. So, and that way I show clear value, and then whatever money you are going to pay me, you know that, look, you are getting value for it. Thank you.
Thank you so much, sir. So there's a third and final question. Considering regulatory demands for licenses before lawyers practice in some intertwined fields, such as cybersecurity, data protection, tech analytics, maritime, etc., does this not hinder lawyers going into these areas of practice? Dr. Yusuf Saleh, please, we'll be grateful for the answers to this question, sir.
Okay, I don't think those requirements restrict or limit practice. Maybe what they do is to say certain activities in a certain sector, you need that kind of registration or license to carry it out. So let's use, for example, for you to be a data protection officer, you need the Nigerian Data Protection Commission to give you a certain form of permission to do that. But as a lawyer, nothing stops you from practicing within the data protection sector, because that is an inbuilt part of your law qualification. So as a lawyer, nothing will limit where you practice, but maybe certain secondary auxiliary follow-up activities may require you to have certain form of permission. But for example, for us within the Nigerian communication sector, we don't have that limitation. So if you're a lawyer, we practice, you don't need a permission to be able to maybe say provide advisory to a license or even to the commission itself. So I just gave an example with the data protection officer, which I think is one of the limitations I see, but it doesn't limit your practice. What it does is limit certain activities you can carry out on behalf of a client. So if you're a DPO, you may be able to carry out data audit exercises on certain companies. But if you don't have that permission, you won't be able to do it. But it won't stop you from providing advisory or services on data protection to any client. But that will exclude you doing audit exercise on behalf of the NDPC, that's the Nigerian Data Protection Commission. So I see that more or less like a procurement activity between you and an agency that wants you to do something. But before you do that for me, get a permit. So that's one part. Then the other part is you want to provide advisory or services to clients that deal around data protection or any other matter for that. I don't see any limitation in that regard. That's my feedback on this.
If I may provide clarification, so in data protection, what you're referring to is actually DPCO, Data Protection Compliance Organization. And if you check the law, there are certain things that they are required to do. And in order to do that, they need specific qualification or expertise. And so the NDPC has taken upon itself to license DPCOs so that the industry or the sector will not be bereft of trained experts in that field. But that does not stop you as a lawyer from advising generally on data protection, like Dr. Sule said. So just note that, Yusuf said. So just note that.
Thank you so much, sir. That was very insightful. Thank you so much. We have come to the end, in the absence of any other questions, we have come to the end of today's webinar session. Thank you so much, Doctor. There's a hand up. Sorry, there are two hands up. Can you just put your questions down so that we'll take it very quickly in the chat box? Because we've already overshot our time. Can you just put your questions down in the chat box very quickly? The two hands up.
Those hands are more like reactions to the post that was made. I don't think
Okay, beautiful. Thank you. So thank you so much, Dr. Sule Yusuf and Mr. Shindebere. This has been a very insightful session. What is clear from this panel session is that the efficiency in technology is no more optional. It requires deliberate investment in skills, systems, understanding. We've emphasized understanding a lot today, and a mindset, a professional mindset. So I think that's a lot of takeaway for all of us, including myself. I've learned a lot from both of you. Thank you so much. We express our gratitude to the Nba-Slp for the opportunity. And in the absence of any other question, this brings this webinar session to a close. Thank you so much. Over to you, Damilola.
Thank you so much. Thank you so much for this. Thank you to Mr. Oshizomire for a very insightful session as usual. Thank you, Dr. Sule, for taking the time to join us. Thank you so much. I'm aware that we have a good number of people from the NCC also on the call. Thank you for joining us today. Thank you to our very esteemed speaker and to our very esteemed guests who have stayed with us on the call. For those who might be wondering how to start with the adoption of technology in their practice, there's a comment in the chat box that you can check out. In the last 2 years, the Nba-Slp designed a few guidelines to guide lawyers on the adoption of technology, on cybersecurity, on data protection, in line with the RPC. The link to access these guidelines are posted on the Nba-Slp website. You can access these guidelines in the link in the chat box, so that in the process of adopting technology, you are in line with what you don't breach your your professional responsibility as contained in the RPC, so that you're within the ambit of the law in everything we do. And once again, to our very esteemed participants, guests, speakers, we hope you make it a date with us again next week as we bring another very insightful and thought-provoking conversation your way from the Technology, Media, and Telecommunications Committee of the Nba-Slp. On this note, we're going to give you back the rest of the Thursday, and we say have a very